Welcome back to the Legal Insight podcast by HHQ. And today we're on episode 14, guys.
Amazing.
And we're actually tackling a very hot topic, which is the Cybersecurity Incident Notification. I'm just going to call it CSI notification under the Cybersecurity Act 2024. Now, I'm joined by our brilliant colleagues from the Technology Practice Group, Ong Johnson, the head of the practice group, and Kai Yi, co-head, and our associate, Nicole. Thanks, guys, for joining again.
Good to see you.
Let's kick things off with you, Kai. Why do you think CSI notification is essential under this new law, the CSA 2024?
Thanks for the question, Zach. It is definitely essential. And the reason why I think that it's crucial, I actually do have 4 points that I can think of. Cybersecurity incident notifications, ultimately, the objective is for you to be able to notify, or rather for a company who is in the face of a cybersecurity incident, being able to quickly notify the relevant stakeholders and the regulators of the imminent cyber threats, right, that are out there. And the reason why it's important is because, number one, it provides quick detection and coordinated response. So the moment I am hit by a cybersecurity incident, I quickly notify the regulators, and then I can have a coordinated response with the regulators. And because why coordinated response is important, because of the impact of a cybersecurity incident on NCII, right? It can actually have cause anxiety among the public. So definitely the response outwards to the public needs to be coordinated with our government and the relevant authorities, right? So that brings me to my second point, better crisis management. How you respond and how you take action, how you deal with and recover and mitigate risk. All these things are important so that you exude confidence in the public, and hence why this notification requirement would give early knowledge to the stakeholders for them to be able to work together with you and give you perhaps the necessary resources and the necessary attentions to manage the crisis better. Again, that brings me to my third point. With a good crisis management response and crisis management plan, right, it can manage public confidence way easier so that there will not be anxiety, right, among the public. Public will not just go into a state of frenzy, but rather they will know that, okay, the company is on top of it, our government is aware, and they're on top of it as well. Last but not least, after you have recovered from the incident, the incident itself will be a very good learning and improving opportunity. The same exploit, the same vulnerabilities that caused the cybersecurity incident can also be replicated to other possible NCI entities out there. So by making it known, right, by making your experience so-called and what you actually went through, how the exploit and how the cybersecurity incident actually took place can help other organizations to learn and help from and learn and be prepared for this cybersecurity incident as well.
Now, Johnson, given how essential these notifications requirements are, how do you foresee these requirements actually reshaping the cybersecurity landscape in Malaysia itself?
From what we are seeing is already happening right now. So this is because not only with the implementations of the Cybersecurity Act 2024, but also with the latest amendment made to the Personal Data Act, which also imposed data breach requirements. So whenever there's a data breach, whether it's a cybersecurity incident or a normal data breach, companies will have these obligations for them to notify. And right now, I would say that almost all companies in Malaysia, they are not able to afford to actually overlook issues such as data security, privacy issue, or even data compliance. I think that Malaysia as a country, we are right now trying to enhance and to cultivate a stronger corporate governance culture in which all companies, all organizations, they have to take data breach seriously. And whenever there is a data breach, whenever there is a cybersecurity incident, they will have no choice but to actually notify accordingly. This will actually boil down to the pointers raised by Kai earlier. This will allow company to also increase the transparency and also allow the common public to actually understand what is happening and also to enhance the confidence from the mass public.
Seems like the serious issues require very serious measures. Nicole, how do you find navigating the notification requirements under this new legislation, given how daunting it may seem.
Thanks, Zach. Yes, indeed. I do think that, with the introduction of this new framework and these new requirements, it can seem daunting to companies. However, I think what we can do is we can dissect it into more manageable components and parts, take it step by step. So the first thing to understand in terms of the notification requirements is when to notify, and of course, followed by what to then notify. Once we take it in parts, then it becomes much clearer for companies. And Zach, I think the key takeaway at this point in time is for companies to just be prepared, to be aware of their obligations and the necessary steps to be taken even before an incident strikes.
Thanks, Nicole. So key takeaway is being aware, being well prepared, and taking it by parts.
Yeah.
So Johnson, now let's dive deeper into the specific parts. Could you clarify what exactly constitutes a cybersecurity incident according to the Act?
Happy to. And I also understand that there are many professionals listening and tuning in to our podcast. The hottest legal podcast in Malaysia. I would like to think so. So when it comes to legal definition, I'm not going to mess this up. So a cybersecurity incident is defined as an act or activity carried out on or through a computer or computer system without lawful authority that jeopardize or adversely affect the cybersecurity of that computer or computer system. So essentially, this actually refers to unauthorized activities that jeopardize or adversely affect the cybersecurity of the computer or computer system. I think the key terms that we really want to focus here will be the two words, jeopardize or adversely affect. This will determine the level of seriousness in order for an event to fall within the definitions. In other words, simply put, the event, it must be serious enough that either jeopardize or adversely affect in order for it to qualify as a cybersecurity incident. This will really determine the level of seriousness. So anything that will not adversely affect or jeopardize the cybersecurity of a computer system, this may not fall within the scope of a cybersecurity incident under the law.
Thanks, Johnson. That's pretty clear. When does the obligation to notify arise under the CSA 2024, Kai?
That is one of the most crucial questions to answer, I believe, when it comes to determining or when does your obligation arises, right? So the regulations, or rather the Act, actually imposes two obligations, or rather under two scenarios where you have to notify. Number one is obviously when you become aware of an exploit or when you become aware of a cybersecurity incident. The moment you have knowledge of third-party threats or an unauthorized access in your digital environment, in your IT environment, you need to notify straight away the moment you become aware of it. Now, this second scenario is a little bit more, I think, gray. It requires some level of discretions, of course. It is when you actually have reasonable suspicion that a cybersecurity incident may have occurred. So you don't have concrete proof yet, but you may have found that maybe there are some suspicious logs somewhere in your IT environment that you cannot somehow account for. It's not an ID, or rather, it's not a log that belongs to any of your employees, right? So that raises a suspicion. And at that point in time, if you suspect that it's actually an action from an external threat, you will have to notify the regulators first before you even come to a conclusion of whether it is actually a compromise, it is actually a cybersecurity incident or not. Now, the reason why I think the regulations or the notification requirement is worded this way, structured this way, is so that at the end of the day, dealing with cybersecurity incidents and to mitigate the losses and to mitigate risk is really it's pretty much like a race against time, right? The faster, the earlier you can react, the lesser your losses could be, right? The better you can contain the damage. So I think that's the whole reason why it is, because it will have to be a race against time, and hence why the notification regime is structured this way.
Thanks, Kai. Now, Nicole, let's take it step by step. Once an organization actually discovers a cybersecurity incident, what immediate steps should be taken?
The first step is for a company to notify the relevant authorities via electronic means. And this is to be done by an authorized representative of the company. Of course, as Kai has mentioned earlier, this is to be done upon awareness of an incident or a potential incident. Now, after the initial notification, which is to be done immediately after awareness, then there will be additional requirements for notification 6 hours and 14 days later.
Now, Johnson, after that initial notification, what additional details must be submitted, as Nicole mentioned, within 6 hours?
Yeah, so as mentioned by Nicole earlier, so the moment you discover there's a cybersecurity incident, you are supposed to actually make an immediate notifications. And then after that, within 6 hours of becoming aware of the incident, so I want to remind everyone is the 6 hours period. The authorized person, then they will need to provide the initial set of informations, which includes informations in relation to the descriptions of the incident, the severity of the incident, the date and time of its occurrence, and last but not least, will be including the methods by which the incident was discovered. So one thing that I want to highlight to everyone is a lot of time when a company, they think that after I make my initial notifications, I have plenty of time in order for me to actually compile, in order for me to actually discover what's going to happen, what am I supposed to plan next. But under the law, it's making it very clear. Let's say I discover something has happened at 1 p.m. in the afternoon. So I was supposed to actually make immediate notifications at 1 p.m. and within 6 hours, which is before 7 p.m., I would need to submit my initial information to the authority. So a company, they should be fully prepared. They should understand that there is only 6 hours for them to actually submit the information. So companies, they must be fully prepared and they need to have an internal policy in order for them to prepare the process of doing so.
Now, Kai, following that initial report, the first notification, then the 6 hour report, within 14 days, there's also a requirement to provide supplementary information. Now, what are those supplementary information?
Yeah, so this is essentially sort of the final mandatory notification requirement under the notification regime, right? Organizations are required to provide further details like particulars of affected infrastructure, estimated number of hosts affected, and also particulars of the threat actors and also the incident. Now, this would cover things like what sort of tactic was used, how did they infiltrate the system, right? So at the end of the day, this last round of reporting to be done within 14 days after the incident was first made aware, right, is really to allow authorities and also for companies to grasp the broader implications of the hack, or rather the cybersecurity incident, and also really to know what was the method used and possibly, if it's at all possible, through the MO and also probably through the signatures, right, to be able to attribute the incident to a particular perpetrator, to maybe a state-sponsored group, so that the tactic used and the method used by this group can be again made known to everybody so that people can take a better precaution of it.
Wonderful. Now, Nicole, what are some of the consequences for failing to comply with these requirements? Say instead of 6 hours, I send the notification in 12 hours. And instead of 14 days, I took a month to send this. Like, what are some consequences?
So, by looking through the CSA, I think it becomes very clear that the lawmakers mean business when it comes to the notification requirements.
Yep.
There are quite severe penalties for non-compliance with these notification requirements. So the maximum fine is actually 500,000 ringgit or up to 10 years of imprisonment or both. So, of course, beyond just the legal penalties that a company may face due to non-compliance with notification requirements, there's also the aspect of consumer and customer trust, right?
Yeah.
So it's like companies do have to keep in mind not only the severe penalties under the law, but also the commercial and practical consequences of any form of non-compliance.
Yeah, so as they say, there's the court of justice and there's the court of public opinion.
Yes.
Both equally consequential these days,
Yes.
right? So, Nicole, when you talk about going to prison, who actually goes to prison?
So when you talk about going to prison, the law actually does make it clear that the directors would be liable, for non-compliance of a company. And the reason that the lawmakers have drafted it as such is so that companies do take it seriously, and they do spend enough time and budget looking into this to ensure that the company remains compliant with the laws.
So directors of NCI entities, take note, yeah? There's no passing of responsibilities here. Kai, what are proactive measures, having that said, what are proactive measures companies should take to prepare for these new compliance requirements effectively?
Again, it's all about racing against time. So to make sure that when you are under stress and possibly panicking, right, you still know what to do at what time. And hence, it's very important that to prepare for the eventualities, perhaps, of a cybersecurity incident, NCI entities should definitely have a very clear, documented protocol, or rather, incident response plan, to know sort of step by step of what to do the moment the company or an employee becomes aware or report a cybersecurity incident, right? And at this level, also, it might be good to also have a committee or maybe a working group that is a dedicated team responsible for handling the compliance part of the cybersecurity incident notification requirement. So all these things can help a company to be better prepared. So when it comes to preparing the plan and also setting up the committee, defining the roles of the individuals within the committee and the working group, work with external legal advisors, work with legal counsels, right, and lawyers to help you out to navigate all these preparatory efforts.
Otherwise, just put us, our law firm, in the hotline. So whenever that happens, just call us and then we can just provide the full support from A to Z.
We can be 24/7 on call, just like doctors.
Right, so guys, there'll be a number, Johnson's phone number here, hotline. Yeah, so having that said, Johnson, as we wrap up today's discussion, what are some final thoughts you have regarding compliance with this new law?
I think as lawyers, a lot of time when we are talking about compliance, when we are talking about corporate governance, it's actually not about compliance and corporate governance. It's actually way more than that. I just want to echo what Nicole mentioned earlier. A lot of times, compliance and corporate governance is really boils down to trust. As we all know that organizations, they take years and even decades to build up trust from our stakeholders, from our clients, partners, and investors. But all it takes is just one simple incident to actually destroy years of efforts that is actually being built, being developed, the goodwill and also the good faith from the clients and from the partners as well. So I would say that all organizations should take these requirements seriously, not only for the compliance sake, but to also protect the reputation, the goodwill that the organization, the companies has spent decades in order for them to develop and also to build.
Now, that's all the time we have for today. Thank you so much, Johnson. Very well said indeed. Now, that wraps up episode 14 of the Legal Insight podcast by HHQ on the cybersecurity incident notification requirements under the CSA 2024. Join us next time for more legal insights. If you're an NCI entity or potential NCI entity, this is something to really take note about. We'll see you next time.